So hopefully that's all of us here now. There are over 200 people that have joined the seminar today, which is excellent. And while I was waiting, I was reflecting on the topic. I absolutely love dilapidations, and I think that dilapidations itself is a hot topic, and that the topics within dilapidations that are hot are should be called hotter topics. So perhaps something to reflect on for the next seminar. All of the topics, and broadly there are three, are ones that we are encountering in our team on a day-to-day basis at the moment. And when I say encountering, they're ones that are in court, and they're in court because they're worth a lot of money and because the answer isn't clear. So I decided or thought that it would be good to talk about some of those topics in a seminar. So if we move on to the first topic, it is to do with missing schedules of condition. And these seem to happen far more often, or that seems to happen far more often than you would expect. Before I talk about what I think you should do if there is a missing schedule of condition, I wanted you to fill in a poll, or I wanted to see where your heads were at when it comes to the situation that we usually face. So imagine you're a judge, you're in the court of session, you're sitting on the bench, and you're faced with a thermal dilapidations case, where the commercial lease limits the tenant's repairing obligation with reference to a schedule of condition. 20 years later, the tenant can't find the schedule of condition, but its surveyor has found photographs of the premises taken at the date of entry, which presumably would have been used for the schedule of condition. Would you, as the judge, let the tenant rely upon those photographs? So if you could vote yes or no just now, we could see. Right. Well, this is interesting. So we don't have as many landlords on the call as I thought we might have. The numbers generally moving between 60 and 70% of you that are saying yes, you would let the tenant rely upon the photographs. 40% of you, a bit less now, say no. And that seems to be that most of you think the most just position is to let the tenant rely upon the photographs. Okay, well, if we move to the next slide, let's see what the law says, or let's see what we think the law says. Firstly, what's a schedule of condition? And I think the context of a schedule of condition is important. Schedule of condition is a document that's agreed between the two parties. There might be photographs in that schedule of condition that the other party objects to. There might be descriptions of defects in the schedule of condition that parties don't accept and they have to negotiate. So it's not simply a record taken by one person that the other person has to accept. It's generally a negotiated contract or a negotiated document, which is revised between the parties with the input often of two building surveyors. I think that's important to remember. Where do you usually find it? Normally in the repairing obligation. It qualifies the repairing obligation. Now, a well-drafted lease qualifies all of the obligations, qualifies decoration obligation, qualifies where it can, the statutory obligation, and it qualifies any other obligation that could apply in dilapidations. Sometimes leases aren't well drafted, and its intention is to qualify all of the obligations, but its reality is that it just qualifies the repairing obligation. That's usually where you see it in the repairing obligation. And it limits the tenant's liability. Normally, schedules of condition are put in place because the condition of the premises at the start of the lease isn't good condition, and the tenant says, well, I'm not going to improve your premises, landlord. I'm just going to give it back to you in the way it is. But lawyers sometimes find it difficult to articulate that in a contract. They use phrases like, it will be returned in no worse condition, or it will be returned in no better condition. They mean two different things and can have two wildly different consequences depending on the repair. One allows the landlord to recover improvements, one doesn't, and one substantially restricts um, the tenant's liability. And I've talked about the difference between the two in a previous seminar and a previous presentation, and I won't go into it just now. But for the present purposes, it limits the tenant's repairing obligation. And moving on to the next slide, it's what do we do if it's missing? The first thing we've got to think about is, does the schedule of condition operate as a benchmark, or is it just a piece of evidence? And to try and put that into context, there was a decision, Master Demolition against healthcare, and I've put in the relevant repairing obligation that refers to the schedule of condition in the slide. And this case was about an old, dilapidated building that was leased to Healthcare Environmental Services Limited. They put this repairing obligation in place, but they never produced or prepared, it seems, a schedule of condition. And Master sued them for the cost of putting the premises into good condition and repair. And the judge looked at this clause and said, well, the tenants accepted the premises as being in the condition as shown in the attached photographic schedule, and it's agreed to return it in the condition shown in the photographic schedule, as evidenced in the photographic schedule. The judge said that the correct interpretation of this clause is that the photographic schedule is a piece of evidence. It's shown in the condition, or it's being in the condition as shown in the schedule of condition, and it's to be kept or not put in any better condition than as evidenced by the schedule of condition. So the judge said, even if there's no schedule of condition here, you can look at other evidence to work out what condition the premises were in at the start of the lease and whether or not the tenant breached that condition by returning the premises in the condition they were in at the end of the lease. So the schedule of condition on this clause was not a benchmark. It was just a piece of evidence. If it's not the benchmark, and if I go back to the start of this topic, usually it is the benchmark. That, to me, is often the commercial purpose of a schedule of condition, is to avoid having to go and ask the person who was in the premises 10 years ago what the condition was like. But if it's not a benchmark, you can go and get any other evidence about the condition of the premises at the start of the lease. And usually the landlord will have to do that before a schedule of dilapidations can be prepared, because there is no way that a tenant or a landlord surveyor, will be able to say that a premises were not in a lease compliant condition at the end of the lease without knowing what condition they were in at the start of the lease. The landlord's surveyor will need to know the condition of the premises at the start of the lease before they can prepare a schedule of dilapidations, because they will only know if the tenant is in breach of that condition if they know what it was like at the start. And that can be a huge burden on the landlord and a huge burden on the landlord's surveyor. And equally, the tenant can go away and find other evidence that the landlord perhaps hasn't found and hasn't relied upon to prepare its schedule of dilapidations. And it can say, well, here are these photographs that my surveyor took at the start of the lease. They aren't in the schedule of condition, but they show the condition at the start of the premises, the start of the lease, sorry. I'm going to rely upon them. So your starting point, if you've got a missing schedule, is to read your contract to work out whether or not the schedule of condition is a benchmark, or is it just a piece of evidence? Now, if it's just a piece of evidence, You can ignore or you do not need the schedule of condition to be able to deal with dilapidations. So the fact it's missing doesn't matter a huge amount if there's other evidence there. If the schedule of condition is the benchmark, then you need to prove the schedule of condition. And what does that mean? If we use our photographs example at the start, if you were to say that this document or that these photographs constitute the schedule of condition, you need to prove that that's the case. So you need to persuade a judge or an arbitrator, whoever it may be, that on the balance of probabilities, these photographs are the schedule of condition. And the judge will either agree with you, and if you were the judges, then 68% of you would probably have agreed with the tenant that those photographs were the schedule of condition. Or the judge will say, I am not satisfied that these photographs constitute the schedule of condition. And the judge is not just making a decision based on what seems to be just. Because if we go back to the purpose of a schedule of condition, it's contained in a contract usually that's agreed between the two parties and negotiated. So we don't know if all of those photographs are accepted by both sides as being representative of the condition of the premises at the start of the lease. And that's the difficulty. It might seem just to be able to rely upon those photographs, but they didn't necessarily comprise the schedule of condition because those photographs don't necessarily reflect what was negotiated between the parties after they were taken. What if your schedule of condition is missing and it's the benchmark? What do you do? Well, you need to look at the contract to be able to work out whether or not the contract imposes a repairing obligation that can exist separately to the schedule of condition. So do the words impose liability on the tenant without the schedule of condition? In Master, the argument was, and there was a number of interesting arguments put forward by Master, but in Master, the argument was the default position is good condition and repair. Might have been correct if the judge has interpreted the contract differently. It might be that the standard is just repair. It might be the standard is something else. Because often contracts are drafted with reference to the schedule of condition, and they don't then put in another benchmark, such as good condition and repair or good repair or anything like that. So if it's missing, it's not necessarily the case that the tenant will be held to an obligation to keep it in good repair or good condition, but it's more likely than not that it will be. Okay, so that's missing schedules of condition. If we move on to the next topic, it's the court reporter. So the court reporter is a person who is appointed by the court either to give it expert advice or to effectively replace the need for evidence. So in a dilapidations context, you will often have a long schedule of schedule of dilapidations. And it will have been negotiated many times between the building surveyors and the mechanical and electrical surveyors, and if QSs are involved as well. So it's a pretty long Excel spreadsheet that you have with a progression of comments. It can sometimes run to hundreds of lines, worth millions of pounds. And if you don't have a court reporter, the way you resolve that dispute or the disputes that exist in the schedule of dilapidations is that the judge hears both parties building surveyors, both parties M&E engineers, and goes through the schedule line by line with them and decides the individual entries. You can replace the judge with a person of skill who will go through the schedule and make a determination on each of the lines, him or herself. And that person, in effect, replaces the judge. So the judge doesn't have to sit through weeks of evidence about whether or not the wall was scratched and what's necessary to repair the wall, because the court reporter will do that instead. The court reporter, therefore, is usually a person of skill who is experienced in dilapidations, usually a building surveyor, most often a building surveyor. And for M&E, it will be an M&E engineer. So sometimes you can have more than one court reporter sitting at the same time. They don't sit in a court. They will go, they will inspect the premises. They will meet with the parties' surveyors. They will meet with the parties' experts. And then they will fill in, usually, an additional column to the schedule of dilapidations or the Scott schedule with what they think the answer is to each of the items. So you would normally use this court reporter in a court action where you have issues that are capable of being resolved by a person of skill, being a building surveyor or an M&E engineer. And what are the pros and cons of a court reporter? Well, you save an awful lot of money by using a court reporter. It could take a judge weeks to go through a Scott schedule. It could take a court reporter days to go through a Scott schedule. And that's because the court reporter is used to dealing with Scott schedules. Most judges aren't. Most judges look at a schedule of dilapidations, an Excel spreadsheet, and they want to run a mile because they're not used to reading and interpreting them and understanding them. They don't like how long they are. They don't know Excel spreadsheet and how to use it effectively. Court reporters use Scott schedules and schedules of dilapidations day in, day out as part of their day job. They also get to go to the premises. It's one of the odd things about our justice system. The judge can't go and do a site visit, or very rarely will go and do a site visit. The court reporter can go, have a site visit with the benefit of both parties' experts, and can look at the defect, can look at the proposed remedy, and can make a decision whether or not the defect exists and whether the remedy is the correct one. So you've got speed, you've got cost benefit, and you've got the ability to actually have on-site inspection with the input and benefit of the parties' experts. So it's quite a powerful way to resolve disputes. It's quite an effective way to resolve disputes of a particular nature. The cons, however, are that court reporters aren't lawyers. They aren't judges in the legal sense. Often dilapidations disputes are a combination of disputes that are purely technical. Does the defect exist? What's the remedy? What's the cost? Court reporter can do that all day long. A mixture of law and fact. Is this defect exists, but in terms of this lease, is the tenant liable for it or not? What is the correct repairing obligation, or what's the correct standard? Is the schedule of condition one the court reporter should have regard to or not? So on and so forth. And some are purely legal. What's the correct measure of loss? A court reporter can't decide or shouldn't decide the law because they're not lawyers. They're not persons of skill in matters of law. That's the judge. So the court reporter might have a limited remit, might have a limited scope if a lot of your items are ones that are a mixture of law and fact. So it can still be beneficial, um, but perhaps can't deal with every item. And so you're going to have an expensive hearing anyway. Might be a bit less expensive, but it's still going to be expensive and time consuming. So sometimes a court reporter just adds another part to the court action. What's important with the court reporter is the remit. And the remit is the scope, it's the letter of instruction. It's negotiated between the parties, and it has to be clear on what the court reporter can or can't do. And the parties effectively have carte blanche to put whatever they want into that remit as long as they can agree it. So the parties could say to the court reporter, you can only decide between the tenant or the landlord. You can't put in your own decision. You can't use your own expertise to decide the defect, whether the defect exists and what the remedy is. So, in an expert determination, the expert can say, I know you, Mr. Building Surveyor, think this, and you, Mrs. Building Surveyor, think that, but my view is something completely different to both of you, and that's the decision. You can say in the remit, I don't want you to do that, court reporter, or you could say in the remit, I do want you to do that, court reporter. You can let the court reporter go and ask the court for guidance on legal issues before they make their decision. You can let the court reporter ask for more evidence. You can tell the court reporter that it's not allowed to have regard to certain items, or they can only have regard to certain items. The choice is yours. But what you have to be acutely aware of is that you are going to be judged by your remit. If something happens that you're not happy with, but it's permitted by the remit, you've got nowhere to go. And what we found in a lot of court actions is people don't spend enough time on the remit. It's one of those bits to a quick instruction. Let's just get it to the court reporter and they'll decide it all and we won't have this dispute anymore. And you don't take enough time to frame the remit, and the court reporter does something that one side doesn't like or didn't expect the court reporter to do. And a great example of this was in relation to a law firm's building in Edinburgh, former building in Edinburgh, where there was a remit to the court reporter. So Scott schedule, number of items were agreed, number of items weren't. Court reporter, the purpose of the court reporter was to help the parties determine the agreed items, or to determine the items that weren't agreed, to decide the items that weren't agreed. But the remit was a bit too loose, and it empowered or it enabled the court reporter to also look at the agreed items. And if he didn't agree with the agreed items, he could change them. And he did that. He took the agreed items and he said, well, they shouldn't have agreed them at that level. This is the level they should have agreed them at. And so he undid effectively the parties' agreement on the items, which I can't remember which side took, I think both sides took umbrage at it. But the court looked at the remit and said, you gave him the power to do that. He did it. There's nothing you can do about it. Another case enabled the court reporter to go and ask for further evidence and to carry out further investigations, but didn't oblige him to do that. There were a number of items where he couldn't see enough evidence to justify the item, but could quite imagine that you could get that evidence. He didn't go and ask for the evidence, and he simply found the items as not being proven. The landlord took exception to that and said, no, you should have gone and asked for further evidence. You should have investigated. You should have asked us to provide you with documentation if it wasn't there, and objected consequently to the decision. And the court said, no, you said that he was enabled. He was able to do that, but you did not oblige him to do that, and he's perfectly entitled to find it as not proven. So your remit is incredibly important. What's also clear from courts' decisions are that they don't like to interfere with a reporter's decision. The general view of the commercial court of the Court of Session is if you have remitted this to a person of skill, you've got to accept their decision. Generally speaking, that's what they'll do. They'll enforce the decision. Even if the court reporter has gone outside of their remit a bit, even if the court reporter has gone and done their own legal investigation and looked at case law and books that were never put before them and reached a decision based on their legal research, the court is going to be very slow to undo that decision. So you have to be very clear about the benefit of it and very clear about the remit. There is benefit, but you have to set your remit clearly. And you can challenge at the very end. I've got bullet point challenge wrong way round. You can challenge a court reporter's decision if they've got the law wrong, if they've gone outside of their remit. And sometimes courts will undo it or order the court reporter to look at it again. But I think the better way to deal with it is to identify any legal issues that you think the court reporter should be giving guidance on by the court before he or she goes to do their exercise. So if there are other things, if there are points of law, if there are other contentious points that aren't in front of the court reporter and you want them to know the answer to those before they go and investigate or inspect the premises and make a decision in the Scotch schedule, deal with them first before it goes to the court reporter. Okay, moving on to the next topic. Good condition for M&E, or as I was corrected recently, M, E, and P. So dilapidations often involves building fabric, which the building surveyor will deal with, and mechanical and electrical, which usually will involve a mechanical and electrical engineer, and also plumbing, which is the P in the MEP. And we often have challenges as lawyers with M&E engineers who are not used to dealing with FRI leases. Not all of them, and some do, and more are becoming aware and understanding of it. But many M&E engineers are used to designing and maintaining M&E, and they don't operate by the benchmark of good condition and repair, which is the benchmark that we usually find in commercial leases and FRI leases. So when you ask an M&E engineer to tell you whether or not a piece of M&E is in a lease compliant condition, is it in good condition and repair, you can often get responses that deal only in CIBSE guideline life or operational or not operational. Those are all relevant to the question of whether or not something is in good condition, but of themselves are not determinative. So what is good condition? And if you've been in some of these seminars before, you'll have seen this statement of what I and we consider the test of good condition in an FRI lease to be. It's an obligation to secure that the premises are in such good condition as one would expect to find them had they been managed by a reasonably minded owner, having regard to their age, character, and locality, and I'll come on to that in the next slides, so as to render them reasonably fit for occupation by a reasonably minded tenant of the sort likely to have taken them at the start of the lease, which contains the same repair obligation in question. That obligation doesn't necessarily extend to replacing new elements for old or to providing any other betterment to any aspect of the premises, but it might extend to that if that's what the reasonably minded owner, etc., so having regard to age, character, and location, reasonably fit for occupation by reasonably minded tenant, would have done in the situation under consideration. That is a mouthful. That's when you're trying to understand what is good condition. That's your test. That's what you're thinking about. I'll come into it in more detail in the last two slides. But just having that in mind, that's the test that the M&E engineers are trying to apply to air conditioning, for example. Is the air conditioning in that condition? And it's pretty hard to know that. Pretty hard for the M&E engineer to know what would be expected at the start of the lease having regard to the age, character, and location of the premises. But that's what they need to have in mind. And when the landlord's preparing its schedule, if it thinks that the M&E is not in that condition, it has to be able to explain with reference to the M&E engineer why it's not in that condition. So you have to work out what you think the benchmark is. What does good condition translate into as the benchmark for that piece of M&E? With air conditioning, it can be, for example, how close it is to the set point when it was first commissioned or when it was first set up. Is it operating within a certain percentage of its design parameters, and so on and so forth? Does it adequately control the temperature in the premises when you test it? And this is the burden of proof and commissioning point. Sometimes with M&E, the only way to know whether or not it's in good condition is to test it. And you need to test it at lease expiry, usually. Now, that's the best point to test it because you then know how it's operating and you've got the evidence, the data to be able to demonstrate that it's not operating in the way you think it should be. If you don't have the commissioning, you might be challenged on whether or not your opinion as an M&E engineer is enough to demonstrate that the item wasn't working as you said it should be. So you could look at the M&E, the air handling units, you could look at the air conditioning system and say, don't think that's in good condition and repair because I don't think it's regulating temperature properly across the office. Response the tenant might get back to you is, prove it. Where's your readings of the temperature across the office under certain conditions? If you've not done that testing, it's hard to prove it. You might be able to prove it subsequently if you can show what work has or hasn't been done, then you can be retrospective about it. But it will become a bit harder. The challenge with commissioning is it's not cheap. You have to invest money in the commissioning using a commissioning engineer with your M&E engineer there at the same time. Sometimes it's not worth it. But if you take anything away from this section in the seminar, it's that you should think about commissioning when you're dealing with M&E. I was speaking to an M&E engineer who's used widely across Scotland for dilapidations, and he's involved in a case where there's a court reporter, and the court reporter, who's a building surveyor, is striking out a lot of the M&E because there is no commissioning evidence. So that risk is high. Getting it right first time, before you have your M&E engineer prepare the report on the M&E, make sure your M&E engineer properly understands dilapidations, properly understands how repairing obligations works, and gets the notion of commissioning and the benchmark standard. There's no point having an M&E engineer and spending the money on one that gives you something back that says this is operational, this is not operational, this is because it will be useless to you. That then relates to the right engineer. Find the right engineer who understands that, or have a good engineer that's an M&E engineer that can get it, that can understand it, and can apply what you've told them to their inspection. Okay, last two slides, dealing with the last topic, which is related back to good condition. This is age, character, and location. So I've got about 5 minutes left, and then 5 minutes for questions. Good condition and repair is not a single standard. So what is good condition in the example I always use of a building is the Shard in London. What's good condition for that building, or for Claridge's in London, or a building of that stature is not the same as what's good condition for an industrial unit in Port Glasgow. They both are the same words, they use the same words, but what's expected, what's considered to be good condition, is not the same. The definition in the previous slide, and we'll share the slides or we'll make the slides available, but the definition in the previous slide refers to what the reasonably minded owner would do having regard to the age, character, and location of the premises. What are the age, character, and location? What is that test? Well, the age is the age of the premises. It's pretty obvious. And it's the age of the premises, and this will be confusing when I come to the next slide, but it's the age of the premises at the end of the lease. So at the end of the lease, if the premises is 2 years old, then what's good condition for a 2-year-old premises, or 2 years old premises? If the premises is 40 years old at the end of the lease, what is good condition for a 40-year-old or years old premises? So that pie, that cake that you're looking at is made up of age, character, location. And so the age of the premises is relevant to that. Now, of course, not all old buildings are buildings, or just because a building is old doesn't mean that its repairing obligation is less. There are some amazing, beautiful old buildings that have a very high repairing obligation in part because of their age. But as a kind of general rule of thumb, the older the building, the less you need to do to put it into good condition. But that's subject to character and location. So character is what type of building is it? Is it an industrial building that's used for the manufacturing of steel? And so actually the person who's going into it isn't really going to care whether or not it's been freshly painted, it's got state-of-the-art air conditioning in it, whether the carpets in the office suite are absolutely pristine, whether the lift is a fully functioning modern lift that goes up and down stairs between levels within a short period of time and is spick and span in the inside. Might not care about any of that. The Shard, however, the people who occupy the Shard care very much about how quickly the lift goes up and down because of how tall the building is and how quickly people want to get to the office. They care very much about what that lift feels like. They care very much what the common parts are like, how nice the reception is when you walk in, how quickly can you get through security, all of these things. So the character of the building is relevant to what constitutes good condition. And then its location. The Shard in London will have a higher expectation that the reasonably minded owner would have of what is good condition compared to what the reasonably minded owner would have in Port Glasgow. And that's because of the likely reasonably minded tenant who would take it on the same terms and conditions, take on the lease in the same terms and conditions. The person in Port Glasgow knows the market and knows they'd probably take it if it was not in as good condition as the Shard is, whereas the person in Shard knows what the market's like in London and knows that it has to be, because it's in London, in a certain condition to constitute good condition for someone to take it on as being in good condition. So the location has a relevance or has an impact on what constitutes good condition. Last slide then. The relevant point in time, apart from age, is at the start of the lease. If we remember what the definition is of good condition that I put up, or that was put up 3 slides ago, the reasonably minded owner having regard to the age, character, and location of the premises so that it would be in good condition that a reasonable tenant would take on at the start of the lease. on the same terms and conditions. So what you're thinking about when you talk about character and location is you're thinking about at the start of the lease, would this be considered good condition having regard to the character and location? The age, you add on the age of the lease or the duration of the lease rather oddly. But you add on the duration of the lease and you think about the character and location. And the sort of leading case in this, an English case, Proudfoot v. Hart, it explains the reason for this quite well. It related to a house in London that at the start of the lease was in a poor area where a lease of the house was taken on, there was a repairing obligation put in place, good condition and repair, where all the houses round about it were pretty poor and dilapidated. 20 years later in London, it became an incredibly affluent area because of gentrification. And at the end of the lease, the landlord said, right, okay, well, having regard to the age, character, and location, this is a very fancy neighbourhood in London, so I expect you to completely upgrade the house so as to put it into good repairing condition, having regard to the age, character, and location of the premises. And the court said, nope. It's not the age, character, and location at the end of the lease. It's the age, character, and location at the start of the lease. Because that's when the parties entered into the lease and that's when they agreed the repairing obligation. That's what was in their minds when they agreed to put it into good condition and repair. So the relevant point is the start of the lease. That creates problems because if you've got a 20-year lease, how do you know what the character and location was 20 years ago? Does your building surveyor know that? Some building surveyors these days, or 10 years ago, weren't building surveyors 10 years ago, weren't even at university 10 years ago. How do you know what the location was, what the character is 10 years ago? So you may need to go and get evidence of that before you prepare your schedule. You may be able to challenge that when you see the schedule. The reasonably minded tenant is the person at the start of the lease who would be likely to take these premises on and would be reasonable in negotiations. Again, you need to have an understanding of who that may have been at the start of the lease. But what they're doing, the important bit, is they're taking on the lease, the same terms and conditions as the lease you're fighting about. The same rent, the same repairing obligations, the same rent review obligations, all of the other thing. What would that person accept at the start of that lease to take it on in those terms? So really what you're thinking about is what would I have to put the premises, what condition would I have to put the premises in for me to have taken them at the start of the lease and paid this rent and accepted this repairing obligation? What would they have to have looked like? Might be that you need a letting agent to give you advice on that or makes it much stronger. That's what you have in mind when you're preparing your schedule of dilapidations. Okay, that brings us to an end. To see if we have any questions, looking at the chat. One question just in relation to court reporters. Can anyone be a court reporter? Yes, generally the parties suggest names to each other as to who should be the court reporter, and they will eventually agree on who that is. As I said, building surveyors will usually be the court reporter for the purposes of building fabric. M&E surveyors, or sorry, M&E engineers should be the court reporter for the purposes of any M&E disputes. You should have two experts at the same time and not in favour of a building surveyor dealing with M&E issues. And you should be insistent on that to the court. So you pick the right person, you pick the person that understands Scottish dilapidations and Scottish M&E and Scottish FRI leases, and they should have a suitable remit and any issues should be ironed out before they undertake that remit. Okay, there are no more questions. So, thank you very much for your time. I've got one question that's come in. What would your advice be if a landlord is selling a property for development at lease expiry? Well, I guess if I'm acting for a landlord, the dilapidations claim is based on the loss that the landlord suffered as a result of the tenant not carrying out the work that it should have done under its lease. So the landlord has to evidence an intention to do the works. Now, if the landlord is selling the property for development at lease expiry, if that's common knowledge, it will be hard for the landlord to be able to demonstrate or prove that it intends to carry out the works. If it doesn't intend to carry out the works, the loss it suffered can't be measured by the cost of those works. So you then have to find an alternative way of measuring the loss. And the alternative way of measuring the loss, the most obvious way, is what impact do the dilapidations have on the price of the property? If the dilapidations were done, would the landlord have got any more money for the property? And that depends probably on what type of development is going to be done. Okay, thank you everyone for your help, for your attention. Any questions, contact details are there. Feel free to get in touch. Um, thank you.